Good evening, this is Rahul Reddy. We are here live from Houston, Texas. Reddy Neumann PC brings live Facebook and YouTube session every Tuesday at 5 p.m. Central Time. Along with me is my business partner, Emily Neumann. Emily, what do we have today?
So we're getting closer and closer to the filing window for the new version of the H-1B lottery. That starts on March 1st. We have a little bit of updates on how that's going to work out. We also saw recently that the Department of Homeland Security published in the Federal Register that they're now reopening the commenting period on their fee increase that's been under regulatory process for a number of months now. And we also know that the public charge rule is going to be implemented on February 24th. We should be getting new forms that will need to be submitted beginning February 24th on that.
Emily, on the cap subject rule, we know that the lottery system is coming. Do we have a URL? Can we now register right now, keep everything ready so that we can submit in March 1st? What do we have?
We have nothing. We have no website. We have no process for how it's going to work. There's nothing we can prepare yet. Our understanding is that beginning in mid-February, employers will be able to create an account in this system. The employer will then mention whether they're using an attorney or not, and that will allow the attorney to then access the system, and then the attorney will be able to submit those registrations beginning on March 1st. We still don't know how the payment process is going to work. Our understanding is once the attorney submits a registration, the employer has to first approve it and verify that they did actually intend for that registration to be submitted. So there seems to be a step-by-step process that happens between the company and the attorney and back to the company again. We understand that employers are able to submit multiple people in one batch, which sounds great, but then apparently if you later change your mind or there was an error on one person in that batch, you have to remove the entire batch to fix it and then do it all over again. So I'm not really sure how this system is going to work, and it's a little concerning. There is going to be a stakeholder call, I believe on Thursday, and another one on Tuesday for employers and attorneys, so hopefully we'll have more concrete information after that.
Based on overall what you're telling, Emily, how the things are going to work, if everything is going to work normally, I'm expecting this process should be more simpler than what it was before.
I agree with you.
Yeah.
That, just the
simpler,
idea of
easier, and better for the people.
having the result by March 30th is going to be
yeah.
so beneficial for so many people, and then having that 3-month filing window instead of a 5-day filing window is going
and
to
not filing the applications which are not selected in the lottery.
Yeah.
So overall, the process is definitely a welcoming process. Hopefully, they're going to work it out very good. It's definitely a better process than the previous process because we used to file all the applications, get all the rejections. It's very frustrating for us to work on the things that are not going to be adjudicated. Right now, this seems to be a simpler process, and once it's selected, then of course we can provide the inclined letter, vendor letter, whatever is required to file the H-1B. Emily, you said that the USCIS has opened the comment period on the filing fees. Did they determine how much they are going to increase the filing fees, or are they going to decrease the filing fees?
So it's definitely an increase. They did announce in the original publishing of the Federal Register what they wanted to increase those fees to, and they pretty much are increased across the board. We're looking at major increase for I-485 filings because they're now going to charge you for the I-765 and I-131, which they haven't been since, 2007? And then the I-129 form for H's and L's is going to get more expensive as well. I-140 I think is going up. Pretty much everything that we do, the plan is for it to be more expensive. And so this original regulation, so they have to basically announce first what they intend to do and give the public an opportunity to comment on it. So we had a 45-day commenting period already. They extended that commenting period, and now they're coming back and reopening the comment period. So either they're not getting good comments or they're afraid there's going to be some sort of litigation and they want to make sure they're doing everything by the book. They didn't give any explanation as to why they're doing this, but we have now until February 10th to submit comments opposing this fee hike. So if you did not submit a comment during the previous 2 periods, now would be your chance. You can expect, I'm going to work on publishing a sample for you on immigrationgirl.com in the next day or 2.
Didn't they promise us they're going to digitize it and all those things? Why are they issuing more forms, more complicated things, Emily?
Yeah, I feel like since I've been practicing immigration, they talked about transformation. That was their word that they named this project for, moving everything to online filing, and then that kind of all fell apart. And now
You're
they
speaking
have,
of 15 years ago,
yeah,
when smartphones were not there.
right, exactly. So they called it transformation then. Now they have a new name for it, which I can't even remember what it is, but they published a little bit more about it in the Ombudsman report that came out recently, explaining what exactly they're intending to do. So yeah, they're trying again to go towards more online filing, but it has nothing to do with these fees. And with these increased fees, they've not given any assurance that they're going to reduce processing times or provide better customer service. They've completely gotten rid of InfoPass, and now they call it InfoMod. Which is practically useless for getting assistance when your case runs into
So you're
problems.
telling that the increased fees is going to get better service, or?
No, that's the thing, is in their proposal, they don't give any assurances that you're going to get better or faster service.
Yikes. So maybe when we are commenting, we should comment on saying that you take the money, but at least provide the services as determined by the legislation. Most of these non-immigrant visas should be adjudicated normally within 30 calendar days, which they are not doing it. So please put a pressure on when you comment on those things. Emily, the public charge rule, as we have mentioned previously in our last session, that may not be applicable to a lot of our audiences which are on business immigration. At the most, it will be affecting only 1% of the time, if at all. But what do you expect? Is it going to cause a problem, like the way, fingerprints? None of our guys have committed any crime or anything like that, but the fingerprint process delayed the entire process. What do you expect when they introduce this new public charge rule requesting more information? What do you?
Yeah, definitely longer processing times, just more complicated. You're exactly right. When they implemented the biometrics for the I-539, for our clients, we thought, not a big deal. We're submitting our fingerprints. It's not like we're dealing with a bunch of criminals or anything like that. So it's not causing any harm to the application's ability to be approved, but it's making it take longer. So the same thing is likely to happen with the public charge rule once that's implemented for employment-based immigration. Very likely you won't see many denials of a 485 or an I-129 because of the public charge rule. But now that there's a new form, the I-944, that you would have to submit with an adjustment of status, new questions on the I-129, new questions on the I-539, the officer now has to review that information. I'm sure they're going to be re-verifying that everything is accurate through their government databases. So certainly processing times won't get any better because of it.
A couple of more updates. We're noticing some RFEs when people were being arrested for one or the other reason. When they file the H-1Bs or H-4, if they don't inform the lawyer, that is going to complicate the matter of you. Please, if you have any arrest records, we recommend that please inform your immigration lawyer that you have an arrest record, and then he will determine what he or she wants to do. Another thing what we noticed is that some of the people who were trying to board the flight, who are on a B2 visa, were been recently requested not to board the flights as their visa has been cancelled. No further information has been provided to them other than the flight people informing those people. And when I inquired about what happened, these particular people who are denied boarding into the flight, they were here before on a B2 visa. When their I-94, before their I-94 expired, they applied for their extension. They even were being granted their extension. They left the country within that extension time. Is that what they told me briefly, but I'm going to investigate more into it. So if any of the people are contemplating and filing a B2 extension, we strongly recommend don't unless it's a medical reason. Because if a person is visiting their children And if they're visiting for more than 6 months, the USCIS does not look that into positive. In rare cases where people require medical attention, that's different. You submit the documents of the medical things, that's fine, that makes sense. But visiting the children for more than 6 months is not a good thing at all. We've been advising people for past 10 years that when you don't apply for V2, it's going to impact the visa that are existing in the passport, but it seems that it's affecting very much right now. So please, when you have a plan to extend more than 6 months, don't just file an application. It has a lot of negative implications to it. Any other updates, Emily, before we go to question and answers?
I think that pretty much covers it for this week.
The question that comes from the YouTube, Emily, is the EAD, H-4 EAD, can a person file more than 6 months in advance? The answer to the question, yes. I mean, you can file it. There is a law that says that if you file an EAD extension more than 6 months, they would not approve it, Surbi. But what we notice is that as of now, not a single case has ever been denied because it was filed more than 6 months before. Not a single case. We will inform you if anything pops up like that with the delay that is happening when you're filing for H-4 EADs right now. If I were you, Surbi, I will take the risk of filing a H-4 plus EAD, EAD more than 6 months. At the most, if they're denied, you can refile the application. But if I were you, I would file it earlier though. Even if it's more than 1 year, I'll file the application.
Lokesh Reddy from YouTube has some questions about premium processing. So what exactly do they mean when they say 15 days processing time? The premium processing allows either an approval or a request for evidence or a denial to be issued within 15 calendar days. So that does include weekends and holidays. So it's 15 total calendar days. You should get something by the end of day 15. If it is a request for evidence, once the request for evidence response is received by USCIS, the 15-day clock starts over, and then it'll be another 15 calendar days before a decision is issued.
Rajesh from YouTube has this question. His I-140 is approved with company A, is now moving to company B. Does company B has to do perm and I-140 or just an I-140? Rajesh, there are two issues here. Was your previous I-140 approved for more than 6 months and it's not been withdrawn within the 6 months period after the I-140 is approved? It must not have been withdrawn within 6 months. In that case, for you to extend the 6 years H-1B, you do not need any labor and I-140 with company B. However, if the previous I-140 was not approved for more than 6 months and it's been withdrawn before the 6 months period of time, you would require both labor and I-140 approval. You can't just apply for an I-140. The company B has to apply the labor and I-140. But Rajesh, based on the Indian backlog right now, if your priority date is very much backlogged, there's no need for the new company to file a perm and I-140 if it's been more than 6 months, your I-140 has been approved and not been withdrawn.
Senthil from YouTube has a question about H-1B amendment filing. So he originally was placed at a different location under a short-term project. That project got extended and the amendment has still not been filed. That is a major issue. USCIS says the amendment must be filed before work can begin, and they do not take that lightly. If the amendment is not filed on time, we're seeing that the amendment will be flat out denied for failure to file it on time. That means you would have to exit the country, file an amendment again requesting consular processing. If you don't have a valid visa stamp, get the visa stamp and then come back in. So if the amendment has not been filed, definitely you should be talking to an immigration attorney. Your employer should be talking to their attorney about how to remedy that immediately because it is a serious problem.
One question that comes up on the Facebook from Madhu and a couple of other people is, can I file H-1B application with 2 employers? The question is very similar to the way I take it is that, can I kill a person? It's so, the answer is, you guys know that. No, you can't. Or can I do it because of this? Can I do it because of that? The answer to every question is no. If ever you want to get a yes answer to me, you will have to make an appointment. And mostly the answer will be, most of the time, no. There are some rare circumstances. It may be, but most of the time the we understand your situation. Maybe this is the last time, or we understand. We have seen so many fraudulent cases in the duplicate filing of the H-1B. We have so many people who went to jail. We have so many people whose life got destroyed, even though their H-1B got approved, their H-1B got revoked at a later time. So the answer to the question is simply no. It's as equivalent as you asking me, can you kill somebody? I mean, it is so simple. You can ask, but you know my answer. No, you can't kill a person. You can't file a duplicate H-1B in the quota.
Vimuli from YouTube wants to know if a person who has an H-4 EAD pending and the online case status is showing your card is being produced, can you work based on that? Unfortunately, no. You have to wait until you have the card in your hand because your employer needs that card itself in order to verify your employment authorization through the I-9 process. So just having that online case status is not enough to be considered authorized to work.
Anu has this question that the passport is expiring within 8 months. Can Anu go and get the H-1B stamping? The answer to your question is yes, you can get the stamping. Absolutely no problem. Anu, one issue that you may want to be very careful is that even though the stamping will be given until the expiration of your H-1B, when you enter into United States, they may only give you I-94 validity until the expiration of your passport. Be very careful. We have seen a lot of people, they enter into it, their I-94 expires, and they are staying unlawfully in this country. So you can get the stamping, come back in, but check the I-94 very carefully. If the I-94 is expiring within the passport expiration, there are one other thing. Once you renew your passport, you can always cross the border and come back and get your H-1B I-94 until the validity. But make sure that you never stay in the country beyond the time period that has been allowed on the I-94.
Nagamani from YouTube wants to know if an H-1B has been expired and the I-94 expired, no extension was ever filed. Can it be transferred to a new employer, and how do you do that? So assuming that you were actually in the U.S. in H-1B status and then you left so that you're not just here without authorization, the new employer cannot file a transfer because you can only file a transfer when you're currently in H-1B status. The new employer can file a new petition for new employment requesting consular processing if you are not currently in the U.S. in some other status, but you don't have to go through the lottery again because you've already been counted within with the past approval. You have to wait until it's approved, get the visa stamped and come back in, or file it as a change of status, but it is technically not a transfer in that situation.
Vikas from YouTube has this question. Can a H-4 person is allowed to invest in stocks? Answer to the question is yes, you are allowed to invest in stocks. Do you need to have an EAD to invest in stocks? No, that is not considered as working. That is definitely considered as investment. Investment in stock market is you're not working, you're sitting at home. It's absolutely legal. Even your uncle in India can invest stocks in USA without him being in this country. Perfectly legal. You don't need to have a work authorization to invest in stocks.
Sarisha wants to know, what is the deadline to submit an H-1B this year and what are the different steps involved? So it is completely different this year. The first step is the employer has to create an account online in order to do the registration. That should be done sometime between February 15th and February 29th. Once that account is set up, your employer will submit an electronic registration on your behalf between March 1st and March 20th. If it's not done by March 20th, you're out, no options at all. USCIS will then conduct the lottery using those electronic registrations, and they will inform employers by March 31st whether the registration for each individual has been selected or not. If yours was selected, then your H-1B petition must be filed between April 1st and June 30th. That's the timeline there. Now, if you are on OPT and your OPT is expiring early in that April to June window, and you're planning on using the cap gap to continue working, know that your H-1B has to be filed before your OPT expires. So if your OPT is expiring on April 15th, your H-1B has to be filed between April 1st and April 15th, not April 1st to June 30th. You have a shortened window if your OPT is expiring early in that window and you're planning on using the cap gap.
Question from Ravi from YouTube has, his wife got a call from scammers for not filing AR-11, and they threatened her, and they got and they gave the passport number. Any big problems? No. If they're calling you for AR-11 not filing, that I would be very surprised if USCIS. I have no recollection of USCIS or ICE calling for AR-11 not filing the application. It definitely looks to be scammers call. If you get any more call, you can please drop an email, give the phone number to me. I'll put your wife on phone and I will call them and speak them if needed. That definitely looks like a scammer's call. You don't have to worry about it. But if they call again, please drop an email to me and I'll have your wife on the phone and speak with them.
Vijay from YouTube has an H-1B amendment in process and also has the underlying petition that's valid until March of 2022. He wants to know if he can go to his home country and apply for the new visa stamp through the drop box using the original petition while the amendment is in process. So the amendment was likely filed for a reason due to a change in the employment, the terms and conditions of employment. So assuming that you are planning to work under the terms and conditions of employment mentioned in the amendment, you have to wait for the amendment to be approved before you can get the visa stamp. Now, if you're planning on going back to the original terms and conditions of employment, the amendment is not necessary, should be withdrawn, and then you can go for stamping based on the original petition. Short answer is, while the amendment is pending, if you try to go for stamping, you're likely to get a 221G waiting for the amendment to be processed before they will issue the visa.
Karthika has this question that she got the I-140 approved, but on the application form there was a wrong SSN number. Karthika, I would just write a certified mail to the USCIS indicating that the Social Security was wrong, and they're not going to act on it. That should be sufficient. Keep that as a record. You actively
I
will
wouldn't
go.
even do that because it's not material.
Yeah, it's not. I would still write a letter because these people get panicked when they look into their I-140 application. I would write a letter saying that, look, there was an error in the Social Security number, and put them in certified mail. FedEx, give it to the client. It's not that the USCIS is going to do anything, but the client will be happy looking at the documents from there saying that, hey, I have sent in FedEx, I have given all the things what is notified. If they don't correct it, it's their problem. That's what I would do.
Mm-hmm. Yeah, I mean.
But the USCIS, as Emily has pointed out, they're not going to do anything on it. It's not that material aspect of it. So I wouldn't be, these step what I pointed out is more to satisfy the client rather than to satisfy the USCIS.
Hemant from YouTube wants to know, what are the processing times for the Texas Service Center because they're not listed on the USCIS website? Yeah, we find that a lot of times that random different types of cases are not listed on the USCIS website, even though we know that Service Center processes them. I would say typically we're seeing anywhere from 4 to 8 months, depending on whether there's a request for evidence at the Texas Service Center.
Praveen has this question with his name, that FNU Praveen Kumar, first name unknown. Will that cause any problem at the port of entry? No, Praveen, I have never seen that causing any problem. Always carry the documentation, what your name is and all those things. We do, the CBP understands the name gets messed up. In fact, my name got messed up. My name is not Rahul, that's my last name. I got messed up and my last name became my first name once I came into the United States. But right now, they do have a very good evidence, Praveen, is that they have your biometrics done everywhere. So when you go for stamping, you got your biometrics done. So when you're coming in, they're checking if you are the right person or not. And if the biometrics matches, the rest everything, we haven't seen CBP giving much problem at all on that.
Jim wants to know, at what point is an H-4 spouse eligible for the EAD? Is it only with an approved I-140, or can it be based on the perm? So there are two ways for the spouse to be eligible. The first is if you have, the H-1B holder has an approved I-140. The second is if the H-1B holder has been granted a 7th-year extension, or an extension beyond the 6-year limit under AC 21, which those can be granted if a perm has been pending for 365 days. So there are some situations where an H-4 EAD is allowed because the H-1 applicant got a 7th-year extension, even if they didn't have the I-140 approved.
Sai Krishna has this question, Emily. I may need your attention. This is a guessing game, I think. When do they start the premium processing for the quota? Is it at the time when we file it, or when the 90 days window ends?
We don't know yet, unfortunately.
I am assuming that it should start at the time when you file. Sai, I may be wrong, but you can come to the regular things. We will update you on the things, because unlike previously, this time they have given a 90-day window. We're not expecting all the people filing the H-1B on the 1st of April. We're definitely not expecting it. So it should be starting on the day you file it, but we will correct ourselves up once more information will come up.
Karthik from YouTube has an approved I-140, and his company merged with another company recently, and the new company is planning to file a new labor certification for him. He wants to know if his roles and responsibilities can be changed at this point. Well, because the new company is filing a new labor certification, yes, you don't have to worry about keeping with the same position in order to qualify for AC 21 to keep your 485 pending, since you, I'm assuming, haven't filed the 485 yet. So since your new labor certification is separate, it has nothing to do with the old one, because the company is filing a labor certification, it is possible that they offer you a different position than what you had before and file the labor based on that new position.
Sirisha has two interesting questions. One is, I'm assuming that she's asking for the quota subject cases. While the H-1B is pending, can she change the employer? No, you can't change the employer. That's gone. That H-1B is gone. The second question she has is that if she files in the normal processing, can the same H-1 be converted into premium processing later on? The answer to the question is yes, you can. One other question is on the Senate 386 bill. Are there any chances of it? Today is the hearing, Trump State of the Union address. We don't know if he's going to, he definitely is going to touch the topic of immigration. We have to see if any motivational words come from him where they can move on the Senate 386 bill. So I would like you to watch the State of the Union address today by President Trump.
Kumar from YouTube wants to know if his spouse is on, or he's on L2 EAD, that's still valid, but his spouse is converting from L1B to L1A. Is that L2 EAD still valid? Yes, it is, because the L2 and that L2 EAD are dependent on your spouse maintaining L status, whether it's L1A or L1B. So as long as that status is maintained, you're eligible for the L2 and the EAD. I don't see any reason that you would have to file another L2 or file another EAD.
Preet has this question from YouTube that the H-1B has been selected in the lottery in 2013, spent 2 years working in United States on H-1B, then returned back to the home country. Can they come back on H-1B and reclaim the rest of the 4 years that are left out of the 6th year? Yes, they can. There is no rule that says that the H-1B must have been counted in the past 6 years. Even though it's more than 6 years, you can come back on H-1B. You're not subject to the lottery. The only one caveat is that when you come back without subject to the lottery, you can only use the 4 years unless you file the labor on I-140. You can't use the entire 6 years.
Anirban from Facebook says, considering the current situation with H-4 and H-4 EAD processing delays, is it advisable to combine the H-1, H-4, and EAD together for filing the extension all-in premium? That used to be work great until about 11 months ago. With this new biometrics, I guess we can't say it's new anymore, but with the biometrics requirement, even if the H-1B is processed in premium, the H-4 and EAD are processed separately under the I-539 processing times. So filing with the H-1B in premium provides no benefit to you. We have found no way to expedite these if it's within the normal processing time. The best option we have found is to file a lawsuit. We file these every 2 weeks. We group together about 30 to 50 different people who have their H-4 EAD application pending for at least 30 days. And once we file that lawsuit, we typically see the vast majority of those EADs are approved by about the 60-day mark from that point. There's no guarantees that every single one of them get approved in the 60 days. Sometimes there are different things that happen with individual cases, but the vast majority do get approved within 60 days of the lawsuit.
I have an interesting question from YouTube. His H-1B question is what he put it as username, Emily. I need your attention, and I may not like your answer, Emily, to this one though. He is writing a blog out of the passion, and somebody monetized that one and gave him a $10.99 for $100. My question is, that looks very odd. I mean, what if I'm running a marathon? When I run a marathon, if somebody hands over $100 to me, I mean, what? I'm just doing for passion. How do we get away from this situation here?
Yeah, that's a good question. I think
I would want you to donate that money to some organization, though, and document it that you donated it for a particular organization. I'm just thinking that may be one of the defense, and contact the organization. Why did you pay me $100? I did not ask you to pay $100. That's another thing. It's surprising. What if I just ran a marathon and then somebody and the organizer told, here is $100 and I'm in trouble, is it right?
Yeah,
I'm just running for my passion. I'm just thinking that you should donate that money to some organization and document it that you just did it for donating that money to that, for any organization. That would be much better.
I would send it back to wherever you got it from.
I would do both the things. Send it back to them and donate that $100 to somebody to not get into trouble. Because if tomorrow, if the USCIS is going to look into the IRS record, even though you send it back, they may not take it. They may take it next year and issue a 1098, I think so. 1099 and 1098 are different. I would still do two things as a defense. Send them the money and then give the $100 to some donation and make a documentation that this is, this is the money that I got it. I wanted to donate it to this organization. I never wanted to keep this one. It was just my passion. I would do both the things to be on the safer side, Emily.
Yeah, I agree. Nikhil from YouTube wants to know, at what point should you start working towards an I-140 after you get your H-1B, and how exactly does that work? So there is no specific time frame, or you don't have to wait any certain period for immigration reasons in order to start your green card process once you are in H-1B status. Some companies do have a time frame. Some companies say you have to work for 6 months or 1 year before you're eligible, but from the immigration rules, there's no such requirement. Now, for the green card process, typically an H-1B holder goes through the employment-based green card process, meaning that their employer is actually sponsoring them. And so, yes, you do need to have your employer start that process with their attorney. It's not something that you as the H-1B worker can just go and file an I-140 unless you're filing under the EB-1 extraordinary ability category, where self-petition is an option. But for the majority of people, you're sponsored by your employer and you have to go through your employer to initiate that process.
Nikhil Guram from YouTube has this question. He wants to record something in the United States, send it back to India, and they will upload it, and can that be monetized? Will that create any problem? Yes, Nikhil, that is considered to be working though. If you're doing that as a passion, not making the money, then I don't see that as a problem. But if you're recording the video and for the purpose of making the money, that definitely is considered to be working. Even though the video is uploaded there, here, while you're in the United States, you're working, that is a violation. But compared to the previous guy, when he was doing for a passion-wise, he was not trying to do for the money, that's a different issue. But you're doing for a monetary-wise, let's say you are taking some classes on Python and then you want to upload it there and make money, that will be considered as a violation. Python is, not the snake Python, but software Python, I mean to say.
Janae from YouTube wants to know if he can work from the foreign office of a company, meaning outside the U.S., and be paid from the U.S. company. So when you are physically sitting outside the U.S. and working in the foreign office of that company, there are no U.S. immigration laws that apply to you. So there's no status to maintain while you are physically outside the U.S. and working for that company. As far as coming back into the U.S., if you were there for 1 year and qualify for meet all of the L1 requirements, and L1 might potentially be an option if the companies have the right relationship. H-1B would also be an option as well, but no issues working from outside the U.S.
Shersh from Facebook has this question. He got his I-140 approved under EB2. Now he's moved to a new employer. They're filing under EB3. Can EB2 be ported to EB3? Absolutely not a problem. As long as the EB2 has been approved and it's not been withdrawn for 180 days, you can port that to EB3. There is no restriction that EB2 cannot be ported to EB3. Absolutely you can.
Palani from YouTube has a question about the 240-day rule for extensions. So his H-1B was already approved and is valid for some time, and the spouse's H-4 extension is still pending. The I-94 expired last year, and he wants to know, does the 240-day rule apply to the H-4 dependent? The good news is no, it doesn't. The 240-day rule is a rule regarding employment authorization. So it is typically for the H-1 holder or the L-1 holder. For the H-4 holder, the H-4 does not provide employment authorization, so you don't have to worry about the 240-day rule. As long as the extension was timely filed, the spouse can remain in the U.S. as long as the extension is pending, even beyond 240 days, even after the I-94 has expired.
This is an interesting question coming on 1099 again, Emily. Vineet from YouTube has sold his used laptop in eBay, and and through PayPal he got the payment, and they sent it 1099.
Oh, huh.
I don't think so. It should be a problem. Vineet, make sure that you have a clear documentation. You can correct me, Emily, if I'm wrong. Clear documentation that this laptop that you sold is yours. You're not doing it as a business. It's just that you sold it. That shouldn't be a problem. And if you sell a home to somebody and you make a profit, that's an investment. That's fine. I don't think so that if you're just selling your used laptop, I don't think so that should be a problem. But make sure you have the documentation very clearly that this money that you got through PayPal is through for selling the laptop, and have the documentation. Send an email or to yourself or something, and make sure it's available to the immigration lawyer, or anytime when you meet with the USCIS or anybody, keep it ready with you that why you got the 1099. You may be questioned at the consulate, you may be questioned at CBP, you may be questioned at any point of time. Keep the documentation readily available. Well, I sold my used laptop, and here is the thing. This is a problem. Can they not live in United States? It looks, it's just sad for people to go through all these things. But I keep the documentation. Now it's over, keep the documentation.
Loki from Facebook wants to know if he can travel to India for 2 to 3 months for a vacation and get the H-1B stamping done for the first time during that trip. So there's nothing particularly wrong with that situation as long as the employer has approved the 2 to 3 month vacation and you have a job to come back to. I typically would recommend that you schedule your visa interview towards the beginning of your time outside the country. That way, if you get stuck, if there's administrative processing or 221G, it will hopefully be resolved by the time your vacation is over and you'll be ready to come back.
Pradeep Rashmi from Facebook has this question: what are the shortfalls or pitfalls that are there converting from H-4 to H-1B transfer? The person is already subject to the cap, so they're cap exempt. The only minus point for that is that when you file the change of status from H-4 to H-1B, unless you have an EAD already approved with the H-4, you cannot work when the H-1B has been filed. You have to wait until the H-1B is approved. That's the one. But if you have an EAD though, you can continue working until the H-1B is approved.
Ananda Raj from YouTube has an L1 that's expiring in March, and the employer is planning on filing an extension of that and also filing a change of status to H-1B in the lottery. And he wants to know what happens if the L1 extension were to be denied before October 1st, but the H-1B gets approved. So when the L1 extension is denied, you're no longer maintaining L1 status. So even though you already have the H-1B approval notice, you're not maintaining your L1 status through September 30th. You would have to exit the United States and wait, get the visa stamp for the H-1 and come back in on October 1st, unfortunately, if that situation were to arise.
Anish got 1099 from the bank. Will there be any problem? Absolutely no problem with 1099 from the bank. It's just you're getting an interest, that's fine. Rajesh Shanmugam has this question: can he invest and trade allowed on the H-1B on the stock market? The answer is absolutely yes, you are allowed to do it. It's perfectly okay to do the investment trading in the stock market.
Let's see here. Secret Santa wants to know, his previous employer had filed an H-1 an H-4 extension, which is valid until December 2021, and then he filed a transfer, filed the H-1 and the H-4 EAD again along with that, and got that extension only till June. So the original H-1 came with an H-4 and EAD valid till December, but then the transfer came with a shorter validity period on the H-4 and EAD. So generally, the H-4 and the EAD remain valid as long as you're maintaining your H-1 status. So if you then extend prior to June and get that approved, the originally approved H-4 and H-4 EAD should continue to remain valid.
Akhilan from YouTube has this question. His brother in India wants to open a IT company in United States. Can he do it? Does our law firm take care of those things? Yes, we do. And the good part about the United States is it's easy to form a company and easy to do business. Absolutely, he can. Now, the second question he asked is that, will it affect anything on his employment if he is going to work for some other different company? No, your brother and you are completely separate. If you're working for some other company, that will not affect none whatsoever at all on your H-1B.
Alan from YouTube wants to know, assuming he gets selected in the lottery this year, can he travel between April 1st and June 30th and then file the H-1B petition after coming back into the U.S.? Technically, yes, that should be doable because the registration is not an actual filing. It just allows you to file. And you do have up until June 30th for the H-1B petition to be filed. So it's not going to cancel your spot in the lottery. However, you have to make sure that the visa category that you're coming in on makes sense still when you're intending to file an H-1B. So for example, if you're planning to come back on a B-2 and then immediately file a change of status to H-1B by June 30th, that's probably not going to be acceptable. If you're coming back on H-4, then there's no issue of non-immigrant intent. The H-1 and the H-4 have the same type of intent required. That's probably okay. So it really depends on what your current status is and how you'll be coming back into the U.S. during that time.
Tinkaram from YouTube has this question. Will the H-1B premium processing extension will be stopped this year? Hopefully not. Hopefully not. That's going to be dangerous if they do, especially with a lot of H-4 EADs and crossing the 240-day rule. Hopefully not. Saurabh from YouTube has this question. Can a student of OPT invest in cryptocurrency? We don't see anything wrong with the cryptocurrency investment. However, though, I want to caution a lot of the investment questions are coming up. One thing is that if you're investing in any stocks that's related to cannabis, or what do you call that? Marijuana, it's not allowed, period. No matter what anybody says, no matter what they say, no matter what the website says, what the investment policy says, you cannot invest in cannabis or marijuana, no. They do say that it's legal, and I'm telling you, it's not legal for the non-immigrant visa people or the non-US citizen people. It's not complete. It is not legal at all. Absolutely not legal at all. For the US citizens, I'm not going to advise that. I will let the criminal lawyers advise what they want to do it. But as an immigration lawyer, I'm advising you, don't invest in marijuana, don't deal in marijuana, and don't invest in any cannabis stock.
Pete from YouTube wants to know if a TD visa can be applied for a non-Canadian spouse. The answer is yes. So if you're in TN status because you are a Canadian citizen, your spouse is eligible for TD or dependent status based on your marriage. It's not related to your spouse's country of citizenship or country of birth. That being said, if your spouse is not Canadian, they will have to apply for a visa stamp at the consulate in order to come in on the TD, versus you as a Canadian citizen, you don't have to apply for a TN visa at the consulate in order to get that status.
Sandeep has this question from Facebook. Can H-4 EAD application be applied when the H-4 extension application is progress? Yes, you can apply it. You don't have to wait until the H-4 is approved. Otherwise, you will wait for 8 months to get the H-4 approval and then 6 months for you to get the EAD approval. At the same time, I'm giving you these timings, but if you want to join the litigation that we do every 2 weeks, you can come and join, because it's taking a long time to get the H-4 plus EAD. We take approximately 40 to 60 people every other week to the court and get their H-4 EADs adjudicated expeditedly.
Sudriptra from Facebook wants to know if an H-4 child has special needs and is undergoing therapy using Medicaid, will the visa extension, stamping, green card process be impacted due to the new public charge rule? So the therapy being received through Medicaid is not considered as a public benefit. It is what they're really looking for to determine that you are receiving a public benefit is, are you receiving income from the government just to survive on a long-term basis? This is targeted assistance because of special circumstances, medical circumstances. It does not fall under a public benefit, which means that you're not going to see a denial due to being found that this is a public benefit. There's not going to be a ground of inadmissibility because of it. Now, will it be impacted? Probably, just because processing times will be longer, but you should not expect to see a denial due to being found inadmissible because of the child's therapy.
Neha, I don't want to name the person anyway. This person has a question. She is undergoing driver. She's on H-4. Can she file a B2 visa, B2, and finish the proceedings and then leave the country? I don't see any problem in it. I mean, that's the only non-immigrant visa that's available for the kind of people for which you are situated at. We don't see anything wrong with it. You should apply for the B2 and make sure that you complete the entire process before you leave the country.
Jim from YouTube wants to know if, at what point are you eligible for the 7th year extension based on a perm that's pending for 365 days? So in his case, the perm was only filed 2 months ago, but it was filed 365 days or more before the max out of the 6-year limit. So you would be eligible to get that 7th year extension based on the fact that by the time you hit your 6-year limit, you would have met the 365-day requirement. Janae wants to know any updates on the proposed rule for modifying the H-1B definitions of specialty occupation and the wage requirements. No updates on that. It is going to be a regulatory process, so the Department of Homeland Security will have to publish a proposed rule in the Federal Register and give the public at least 60 days time to comment on that proposal. We have not seen a proposal yet specifically on the specialty occupation definition. I think the earliest we might expect to see that is not until October of this year. So it's not something that's going to happen in the very near future.
Niti Sharma has this question: are there any changes that are expected in the employer-employee relationship issues when we are filing the H-1B extension? There are some proposed regulations at this point of time. I mean, they're not officially proposed, they just put them in the timeline, Niti, that may affect the employer and employee relationship for the H-1B extension. We would in generally advise people, if you can get a job with a direct employer, you will be in a much better situation rather than working with a consulting company. We are facing a lot of difficulties in getting the H-1B approval with the consulting companies. So if I were you guys with everything in place, everything in perfect shape, you should try to go and join the end client directly rather than working through consulting companies.
Sundeep is on H-1 and is planning to take a job offer that's actually in a different state. His family, I'm assuming, is on H-4 and they're going to stay in the current state and he's going to travel back and forth. He wants to know if that's a problem for the H-1B. No problem at all. It's not a problem for the H-4 dependents because you are maintaining your H-1 status by working for that new company. It does not matter that it's in a different state. If you want to commute once a week or back and forth, that's totally fine.
How much risk does a job role change in the H-1B with the same employer being for a full-time employee? Well, it depends on, is it a minor job change or is it a major job change? That's the number one question that will be. The second question is that it is also not what the lawyer feels. What does the employer feel? That is it a minor job change or a major job change? Sometimes people will feel that moving from Java to SAP is a major job change. For me, it's all the software. The Java is a software and this is a software. That's the way I feel. So it also, if the employer and employee feels that it's completely different job, then there's not, then you have to file an amendment. So it is a perception of you and perception of the employer and also perception of the lawyer. Definitely I feel that if you are making a Java coffee, not the Java software, and you move to SAP, no matter who considers what, it is a job change. I'm speaking of the coffee Java, not the software Java you guys are speaking.
Karthik from Facebook wants to know, he has transferred his H-1B to a new employer and it's been approved. His old employer is withholding his pay for 2 months of his salary. He wants to know what to do in this situation. You do have the option of filing a complaint with the Department of Labor. There's a special form specifically for H-1B workers called the WH-4, Wage and Hour 4. And you have to do this within 1 year of leaving that company, and you would submit all of the information to them. They'll review the information. It will likely lead to a wage and hour investigation of the company. And if it's found that the company failed to pay you properly, they will be required to send you a check. And it's very possible that other employees who've had the same thing happen to them for that company will also receive back wages from the company as well.
I would do one thing, is that instead of sending it to the Department of Labor, you can do one thing: fill the WH-4, send it to the employer and tell, hey, you pay me my money, otherwise I'm going to complain to the Department of Labor. You may get a faster result. I see them, employers responding within the same day if you send those kind of things. Fill it, send it to the guy, hey, pay me my 2 months salary, or I'm going to send the complaint. If the guy doesn't respond, send it to the DOL. Surabh Shastri is on O1 visa. Employer does not deduct the FICA and Medicare. They are supposed to deduct on O1 visa. On STEM extension, it's different, but not on O1. You should check, have your accountant discuss with and have the FICA and Medicare getting cut though. That's different when it comes to the student visa, but it's quite different when it comes to the O visa. Have it corrected by your accountant.
Tam from Facebook has 2 patents, speaks at many events, publishes articles in magazines, and earns more than $525,000 a year and wants to know if he can file under the EB1 categories. I'm assuming you're referring to EB1A for extraordinary ability. Well, it certainly sounds like you may be able to meet some of the requirements. What they really need to see is a comparison between, if you're trying to base it on salary, yeah, $525,000 sounds like a very high salary, but if most people doing what you do receive that same amount of money, then comparatively speaking, you're not receiving a high compensation for the work you're doing. So it all depends on comparison for the salary. They want to see not just that you've published articles in magazines, but are those magazines well known? What are they scholarly magazines or are they business magazines? Are they known for contributing to the industry or the field? Speaking at events, again, they want to see that these are high-level events. How many people attend these events? Who else was speaking at that same event? How did you get invited or to speak at that event? So there are 10 different criteria. You have to meet at least 3, and just meeting the 3 by itself is not enough. You have to show that you meet those 3 and you are at the top 5 to 10% of your field. So it sounds like you're definitely there or close to it, but you would definitely want to consult with an attorney to go through the whole background and see whether you can meet all of the requirements.
One other question that came from Chandu is, can multiple applications be filed under the new quota? The answer is no. I've answered previously. It is just like asking, can I kill somebody? The answer is no, absolutely not. Don't kill anybody and don't file duplicate applications in the quota.
Akilanan has a good question. We've been talking a lot about taxes and 1099s and income and investments. He wants to know, when would USCIS actually request tax documents? So this typically comes up when you are at the adjustment of status phase. So if you're an employment-based category, generally the affidavit of support is not relevant to you personally because you are getting your green card based on an offer of employment where the wage is enough to support you. But when you are bringing dependents along with you, you might submit your tax return with an affidavit of support for your dependents to show that you will make enough money to keep your dependents alive and able to care for them while they are in the U.S. So that's typically when you would submit tax returns.
Also, I've noticed, Emily, that they're inquiring more into the employment 1090 and the W-2 forms also at the port of entry, though. So if there is anything like, for example, a 1099 has been issued for selling the laptop on the Facebook or on the eBay, which is a used laptop, I would rather want to have a clear documentation ready there to at the port of entry too. I may want to have that, especially when you go for the stamping also, when they get any doubts, so you can clarify them. As things are changing right now as compared to what the things were before, I would keep anything available whenever you want to. So make them available, ready for it when you want, especially when you're entering into the country or when you're going for the consulate.
All right, I think we've about run out of time for today, unless you have any last questions.
Yeah, the Chandu is asking that if does the electronic system has multiple petitions will be rejected. They are not going to reject it. They are going to, if they are filed for different companies, they are approving and then going for the prosecution. That's what they are doing right now. And that's what they've been doing from 2016 also, but we didn't know that they were doing. Now they're going back to 2016 and revoking all those H-1Bs. So even if they find that two people, because the passport number, social security number, and the date of birth is already there in there, your passport number is there, so they will do it. They may not reject it, they may approve it and then revoke it.
Yeah, I definitely think that they do that on purpose. We find they don't do any kind of vetting for fraud really before. It's always after the fact, and they approve these cases on purpose because it kind of entices the bad actors to keep doing it. So they're going to keep approving it and keep approving it, and they're just gathering evidence to use against the bad actor, which is generally the employer in that situation. But the employee gets caught up in it as well because your H-1 eventually gets revoked, and if it's your very first H-1 that gets revoked, you're not considered to be counted in the cap from the beginning.
I have to tell you another story, Emily. When I started practicing in 1997, I have determined one particular client that he's definitely not eligible for the green card. And he paid me consultation to come back to me and showed me that he got the green card. And later on, I was inquiring about it. He bribed the official. And through that, what happened is that there was a line of people, 100 people bribed the same official. And then later on, that official actually was working with the USCIS to trap all these people and throw them out of the country. I feel that the lottery system is inviting people to get into trouble. It is inviting people to do that fraudulent activity. Please don't cooperate, don't do anything for filing the duplicate applications. Don't do that. You'll be in trouble. Your company is going to be in trouble. Some of these operators and company, they'll close the company and they will leave. You're in trouble. So don't do that.
All right, well, thank you so much for joining us today. If we didn't get to your question, you can always join one of our daily conference calls by going to reddyneumann.com or rnlawgroup.com, and click on conference call to get our schedule there. That's every day. You can ask your questions. You can always visit immigrationgirl.com and post your question there as well.
Thank you guys for tuning in.